Let's talk about something that's absolutely fundamental to your liberty as a citizen. Article 22 of the Indian Constitution. It's all about your rights if you're ever arrested or detained. So, what are they? What do you actually need to know?
Okay, just picture this for a second. Someone says those words to you, "You're under arrest." In that moment, what happens next? Do you know what you're legally entitled to? This isn't just some movie scene. Knowing these rights is crucial for everyone.
So the very first thing you've got to understand is that not all arrests are created equal. Article 22 actually lays out two totally different legal paths, and the rights you have are completely dependent on which one you find yourself on.
But let's back up for a sec. What do we even mean by an arrest? Well, in legal terms, it's pretty simple. It's the act of taking away your personal liberty. Now, this is usually because they're investigating a crime that's already happened, or, and this is where it gets interesting, to stop one from happening in the first place.
And this is that fork in the road I was talking about. Path 1 is what we all think of, right? An arrest for something you've allegedly already done. But Path 2 is way more complicated. That's when you're detained to stop you from doing something you might do in the future.
All right, let's start with the one we're all more familiar with, an ordinary arrest. This is the most common scenario, and it's governed by some really specific rules that are designed to protect you from being detained illegally and make sure a judge gets involved fast.
There are three huge, non-negotiable rights here. First, they have to tell you why you're being arrested, and they have to do it as soon as possible. Second, you have the right to talk to and be defended by a lawyer, any lawyer you choose. And third, this one's a biggie, you have to be brought before a magistrate within 24 hours. The police can't just hold you any longer than that without a judge's say-so.
Now, let's switch gears to that second path, the one that is frankly pretty controversial, preventive detention. This is when the state detains someone not for something they've done, but to stop them from doing something they might do.
Yeah, just let that sink in for a minute. You can be deprived of your liberty based on a suspicion of what you might do. The Constitution does allow for this, but only under very specific conditions. You know, things that threaten the security of the state or public order, and it comes with its own set of rules.
The protections here are just different. You still have a right to be told why you're being held and a right to argue against it. But instead of seeing a judge within 24 hours, your case gets reviewed by something called an advisory board. Think of it as an independent group that checks that the detention is justified. And critically, the law has to spell out the absolute maximum time you can be held.
This table really just lays it all out, side by side. Look at the reason, past act versus a possible future act, and check out the oversight, a magistrate in 24 hours versus an advisory board. It perfectly shows you the two completely different worlds of detention that exist under our law.
Which leads to a really important question. Why on earth would a constitution that's all about liberty even allow for something like preventive detention? Well, the answer goes way back to a huge Supreme Court case right after the Constitution came into being.
The case you need to know is A.K.Gopalan versus the state of Madras, all the way back in 1950. This one case is pretty much the foundation for how we understand preventive detention in India today. So here's the story. A.K.Gopalan was a well-known communist leader, and he gets detained under this new Preventive Detention Act. So what does he do? He takes his case straight to the Supreme Court, and he asks this massive fundamental question. Can the government just lock someone up without a trial because it's afraid of what they might do?
And here we have it. This is the core of what the court decided. They said, yes, the state does have this power. But, and this is a really, really important but, it can only use that power if there's a clear legal procedure in place. The power isn't unlimited. It has to follow the rules.
So here's the bottom line. The court gave the law a thumbs up, but it tied the government's hands with procedure. It said, yes, this power exists, but it's only constitutional if those mandatory safeguards we talked about, telling you why, letting you make your case, having an advisory board review, are all strictly followed. This case basically gave the green light to prevent a detention, but only within the very narrow lane laid out by Article 22.
Okay, so we've been through a lot of detail. What's the big picture here? What's the one thing you should really take away from all this?
It's this. Article 22 is basically a giant, constant balancing act. On one side of the scale, you have your fundamental right to be free. On the other side, you have the state's job to keep everyone safe and maintain order. The entire point of this article is to try and find that perfect, delicate balance between two incredibly important and often competing ideas. And that really just leaves us with one last, massive question. The law gives us a framework, sure, but it's us, as a society, who have to wrestle with this all the time. Where do you draw that line? At what point does the need for security become so important that it's okay to restrict someone's freedom based on something they haven't even done yet? There's definitely no easy answer to that one.